Hello everyone, this is going to be a continuation of AP Government on Insta, episode 1. So this is going to be part 2. And so in this video, I'm going to read parts of an Atlantic article. And there's so many different elements that I kind of want to convey to you. So hopefully I'm able to do it with brevity and then get to talk a little bit more about a lawfare article that I have for you as well on the most recent impeachment trial. So I'm going to talk about media literacy, talk about AP government and how to write an essay. Where I highlighted it, I have a particular point attached to it. So these are my notes so I can kind of remember to convey these things. So first and foremost, I really like to read The Atlantic. I think it is a very reputable publication that often features, experts from a variety of different domains, whether they be constitutional law or economists. It is a little bit left of center, so it might not be appealing for some of you, but I do enjoy it, and I have a subscription to The Atlantic, and it is one of the nation's highbrow media publications. So anytime you're reading, though, one of the core elements of this, or AP government specifically, was I wanted to convey to you that there are different types of writings and different types of journalism, right? So there's commentary or analysis, which this piece is kind of a blend of both. There's also reporting. There's no original reporting done in this essay. So reporting, you can think of it as sort of a descriptive essay. It involves some investigatory work. Usually the best reporting involves investigatory work, cultivating sources and stuff like that. That's not what this is. This is more commentary, meaning it's developing an argument and a bit of an analysis as well. There's analysis that's really embedded in reporting and commentary, but sometimes there's articles that are just, trying to analyze a news event and provide insight to the reader. This one is kind of a blend of both. It's going to provide a specific argument. It's going to make a specific argument and provides analysis for those that are not constitutional legal scholars to better understand the arguments that are advanced by former President Trump's legal team in the last impeachment trial. All right, and this article, if you haven't already told or couldn't already tell, is critical of former President Trump's legal argument in the last impeachment trial, or at least the one presented by his lawyers. And so the article, so first things first, every time you read a news article headline, it's always going to serve as a hook because they want you to click on the news article, right? So don't just share an article if you just read the headline. You got to read the article, put in that work, right? And make sure it's from a reliable source. I'm sorry, there are different types of sources, and so not all sources are the same or deserve the same credit or merit. So freedom of speech doesn't mean what Trump lawyers want it to mean. That's a hook, so be careful. Then all that SOAP analysis comes in. So my shout out to my EP World History students. We did SOAP every day, and we said that we always have to think about the speaker's backgrounds and intentions and stuff like that. We always have to be critical thinkers. We don't necessarily have to be skeptical or cynical and all that types of stuff, but we definitely need to be critical of these people's words. We want to know what are these people's qualifications in advancing the argument that they have. So we see here that Keisler, I guess that's how you pronounce it, he's the former acting Attorney General of the United States. So he used to be pretty high up in the Justice Department, which requires, in my mind, a lot of knowledge about law. And then I actually looked him up, and he used to serve in the George W. Bush administration. And then this guy, I don't know his name, Richard D. Bernstein, but I know he's an appellate lawyer, presumably an appellate lawyer with high-profile cases because this is The Atlantic, right? And then I'm going to go ahead and read for you here. Front and center in the former President Trump's defense this week will be the argument that convicting him and disqualifying him from holding future office will violate his First Amendment rights, that it would essentially amount to punishing him for speaking his mind. His new lawyer, David Schoen, has warned convicting Trump is putting at risk a passionate political speaker, which is against everything we believe in this country. And then the article continues, and this is where you can think of like the thesis statement of the article. This is wrong. Even if the First Amendment protected Trump from criminal and tort liability for his January 6th exhortation to the crowd that later stormed the Capitol, it has no bearing on whether Congress can convict and disqualify a president for misconduct that consisted in part of odious speech that rapidly and foreseeably resulted in deadly violence, right? So this is a popular news magazine, And it's kind of an interesting audience, right? We have to consider who the audience is. It's a highbrow intellectual audience, but at the same time, too, it's not necessarily an audience that knows a lot about, constitutional law, but it is also an audience that wants sort of like oomph, like a hook with it, like a component of, passion in the writer. So it's a very specific type of essay. But we can see here elements of essays that you've written in AP Lit, in previous classes, and AP Government. We can see that the authors lead with the counter argument up front. They articulate the counter argument first. And then their thesis statement is that is wrong, right? And it's a little bit informal, right? It's kind of trying to, that is wrong. All of that is nonsense, right? It's kind of a rhetorical device used to kind of advance their argument and make it more convincing, even if the First Amendment protected Trump from criminal and tort liability. So it's kind of leading with a yet statement that Mrs. Smith talks so much about it for his January 6th exhortation to the crowd that later stormed the Capitol. It has no bearing on whether Congress can convict and disqualify a president for misconduct that consisted in part of odious speech that rapidly and perceivably resulted in deadly violence. Okay, and then the evidence here too, and I'm going to try to cut this as short as possible. It talks about the evidence that is used, right? And this is, remember, in AP Government, the evidence that we're going to use a lot, because this is it's an argument about the constitutionality of impeachment, or it's a legal argument, right? So it's going to use similar evidence to what we use when we're making our AP Government essays. And it talks about how one of the Supreme Court cases that President Trump's defense cited in the impeachment case was Brandenburg versus Ohio. This wasn't a required Supreme Court case, but we did a SCOTUS application about Brandenburg versus Ohio, and we compared it specifically to Schenck versus the United States. Remember all those IRACs we did with Schenck? So specifically with Schenck versus the United States, at issue was determining whether Schenck could be convicted under the Espionage Act. And I'm not going to get into the details here, but the SCOTUS said that he could, and it didn't violate his First Amendment right because there was an imminent danger and threat, right? So it set that standard. But in Brandenburg versus Ohio in the 1969 Supreme Court case, it held that the First Amendment prohibits criminal liability for advocating violence that is not imminent. So if violence is imminent, or the danger is imminent, then it's not protected by the First Amendment. But the Supreme Court determined that in Brandenburg versus Ohio, if violence is not imminent, it is protected by the First Amendment. Or that speech is protected by the First Amendment. And then there's the analysis portion of this. According to their theory, Congress could not impeach, convict, remove, or disqualify a president like Clarence Brandenburg. But then it kind of argues like, look, wait, impeachment is not the same as, impeachment is different from a crime. Impeachment, conviction, or removal, you don't have to impeach someone for a crime or criminal conduct. It doesn't have to be specifically a crime. Impeachment is a specific constitutional process for exceptional circumstances and stuff like that. I'm probably rushing the analysis so I can get to the second part. So this is a lawfare article that I found fascinating. I'm going to put the link in the description. I'll also put, I guess, the link, I don't know where I'm going to put the link here, but I'll put it in the AP Microeconomics section or whatever. But you can go ahead and continue reading from here if you so desire. It's a fascinating article, obviously with interesting analysis. This is the impeachment trial diary. Again, look at the authors. And so in this, you actually can't really find a thesis. It's just a diary and analysis that happens day by day from Benjamin Wittes. And this is an intern. She's a lawfare intern, I believe. I love lawfare. I have my lawfare shirt on right now. It's got some great analysis about thorny legal issues and stuff like that. And it also talks about sort of the constitutional arguments advanced by President Trump's defense team, former President Trump's defense team in the impeachment trial, and all that good stuff. Okay. And also, of course, the House impeachment managers as well, the arguments that they advanced and the counter arguments. It's very cool, very good, and I recommend it.